So obviously, we're in an environment, and most of you have heard of any number of the accounting firms, especially the large accounting firms, being sued, whether they're being sued by the government, like SEC, or they're being sued by shareholders or lenders, class action suits. Auditors are subject to, legal liability. And we also have a changed legal environment, and a lot of it has come out of just, the huge scandals that we've seen. And scandals are not unique. It's not as though the WorldCom Enron era happened and it was so new. I mean, there's always been audit scandals where auditors have been sued because of lack of, appropriate audit procedures and, issuing an opinion on financial statements that were incorrect because they did not perform an audit with due diligence and due care. So it's not new, but there's, in this environment that we exist in today, where everything is, instantly hits the news media and it's on a constant news loop, people, so it's in your living room all the time. So people are more aware of these, they were more aware of the Enron scandal. It was so big. They're more aware of the WorldCom scandal and the PCAOB and Sarbanes-Oxley and the fact that there were hearings at Congress. So the legal environment has really changed. So yes, auditors have a responsibility, obviously under common law, to comply with the contract. So when they're engaged by the client to perform an audit, there's a contract. We call that the engagement letter. Right? There's a contract that they sign that basically says we're going to do X, Y, and Z, and you're going to provide us with A, B, C. Right? And we're going to deliver these financial statements. The client will say we need our financial statements. If it's a publicly held company, you have a deadline, because your financial statements have to be filed with the SEC by a certain period of time. Otherwise, you face penalties. So the auditors have a legal responsibility just based on contract law. You enter into a contract with another party, you're responsible to fulfill your end of that contract. Also, the auditor is subject to liability because of the fact that they're providing an opinion on information that the client makes assertions about, and they could be sued for negligence, right? So they met their contractual terms, right? They lived up to the contract, completed the audit by the agreed upon date, and delivered what they agreed to in the contract. But then after the fact, we find out that the company had to have a restatement or so forth. And so they're liable to their clients if the client says, you know what, you should have caught this. You were negligent. Right? You didn't perform the audit with due professional care. So auditors are also liable to their client for negligence related to a breach of contract if they don't perform the audit with due professional care. Right? So let's talk about, we already talked about this, about the highly publicized cases. That's why we're seeing an increase in lawsuits, just how much people are aware. And also the major audit firms are deep pockets. Right? It's that big pocket syndrome. And especially if the company goes bankrupt. Well, where am I going to get my money? How am I going to be compensated for my loss? Who do I turn to? Because my stock is worth nothing. I can't get anything from that company, so I'm going to sue the auditors. Right? So the other thing that we're finding ourselves in an environment where the accounting standards are transactions that company engage in are way more complex. Right? So it's easy, accounting. I make widgets and I sell widgets to my customers, and my customers pay me for those widgets. So I, credit sales, debit accounts receivable. When I collect my cash, I credit accounts receivable and debit cash. I make my widgets or purchase my widgets from a third party, debit inventory, credit accounts payable. When I pay, debit accounts payable, credit cash, right? Those are pretty straightforward transactions, arm's length. But then we get to the fair value, for example, or financial instruments or derivatives, right? Those transactions are way more complex, right? Especially in a situation where there's no observable market. We can't go to Google and look at the stock exchange and see what the company's stock is trading for, right? That's observable. What about when there are unobservable markets? or assets, so we have to develop the value of that asset based on models. Right? How many of you have done modeling? Neither have I. Don't want to. Right? So, but if you're an auditor, and now you have to audit fair value measurements. And forget that, the auditor, imagine a third-party investor, shareholder. They pick up the financial statements and they see this market value for something that's called a level 3. What the heck does that mean? That you couldn't observe it in the market. Well, how did you come up with this price? So the transactions are way more complex. Also, as I said, they're more, the auditors have that whole deep pocket. So they're an attractive target when there's an audit failure or financial statements, a company goes bankrupt or has to issue a major restatement. So the sources of auditor liabilities are in the two things: common law, which means that would be clients or non-shareholder third parties, such as lenders. And then there's statutory liability, which would be shareholders under the Securities Act of 1933 and 1934. So common law and statutory liability. The types of third parties, and this is important, is the primary beneficiary. There's the primary beneficiary. So what that's saying is the auditor knows that when they issue this audit report, when they entered into this contract, they know who the primary beneficiary is. So obviously, if the audit, if the client hired the auditor to issue an opinion on the financial statements, well, the auditor knows the company is the primary beneficiary. So it's known by name to the auditor. The auditor knows that. The foreseen party is parties who could reasonably be expected to rely on the work of auditors. So you could imagine, if it's a publicly held company, right, and if it's a publicly held company, or if, let's say, if it's a company where the company engaged the auditor because they're trying to get a bank loan, right? And this particular bank, the bank, let's say Bank of America, said to the client, you have to have audited financial statements. You have to have your statements audited by an independent CPA firm, right? So if the client makes that known to the auditor, then that is a foreseen, right? So they know that those parties are going to rely on the financial statements, right? Or if, or another example would be if you know that the company needs these financial statements because they're applying for loans. Again, that's foreseen. You might not know the exact bank, but you'll know that the purpose of those financial statements. And then foreseeable parties are parties whose decisions normally rely on audited financial statements and the opinions on those financial statements. So that would be shareholders, investors, right? You don't know. I have stock. Some of you may have stock. I don't know. But the auditor doesn't know that I have stock in Pepsi or I have stock in some other company. They don't know. So I can't say, you should have known I had stock, right? But because Pepsi is a publicly held company or Google is a publicly held company, the auditor knows that there are some foreseeable parties who are going to rely on those financial statements. So the sources of liability, 4 major sources of auditor liability would be their liability to the client. And so that would be where the client sues the auditor for not discovering a material fraud, right, or error in the financial statements. Because the client is saying, look, they'll probably sue the audit, you were negligent, because had you done your work, or had you conducted the audit with due diligence, you would have found this. So they can sue the auditor for that. Then there's liability to third parties under common law. So an example of that would be a bank sues the auditor for not discovering an error in the client's financial statements. There's civil liability under federal security laws, and that's usually when shareholders would sue the auditor for not discovering errors in the financial statements. And then there's criminal liability where the federal government prosecutes the auditor, right? So you would see the SEC, for example, bringing a suit against auditors for for filing an incorrect audit report. So auditors obviously are not standing around and just waiting to be sued, right? Or they accept all lawsuits and say, oh gosh, you know, got to pay this out. They're going to try to defend themselves in certain cases, and the different defense, some of the different defenses that they could use against client suits would be a lack of duty to perform, which is why engagement letters are important. It's your contract. So they could say, we didn't have a duty to perform that. Based on the contract, based on the engagement letter, we laid out what our responsibilities would be and what your responsibilities are. And we had no duty to perform that. Right? Another defense might be non-negligent performance. And basically the auditor is saying there is that we did our job in accordance with generally accepted auditing standards. We don't provide absolute assurance, we provide a reasonable assurance. And based on the work that we did and the evidence that we collected, we did our job in accordance with generally accepted auditing standards. So we were not negligent. We acted in good faith, and we exercised due diligence. And you could say, look, we were not aware of any, because of that, we were not aware of any misstatements. Our work papers support our opinion. And that's, again, in these types of situations, this is why documenting your audit work, your evidence is so important, right? Because that has to serve the basis not only to support your opinion, but also as an auditor if you find yourself being sued by a client. Or you find yourself in situations where the government is coming in, the SEC, and looking at the audit work you performed on a client. The other thing that the auditor commits, contributory negligence, right? So the client contributed to it. It was negligent behavior on part of the client that's caused the loss. So the client, in other words, was responsible for the loss. If you had a system, so for example, the auditor might claim, you have a system of internal controls that were ineffective, right? And because they were ineffective, you were not able to detect, you didn't have a process in place to effectively, to detect or prevent errors from occurring. So prevent a fraud from happening, right? The tone at the top was lax. You didn't have, you disregarded recommendations that we made, right? So the auditor can say, so because of that, you contributed to the loss. Or if the senior managers engaged in a fraud, you contributed to the loss. You have responsibility for the financial statements. And then finally, absence of causal connection. So the loss was caused by other factors, not the financial statements, not anything that the auditor did with respect to the financial statements. Under the common law and under different types of liability, this is just a table that kind of tells you what the burden of proof is, who has the burden of proof, and summarizes what the auditor's defenses is. So under common law, which is brought by clients, brought by a client, the client is going to sue the auditor for breach of contract or ordinary negligence, gross negligence, or failure to find fraud. Okay, the auditor could say the breach is inappropriate, there was no breach, they had no responsibility to perform, it was caused not by anything that they did, and the client contributed to the negligence. So those are just some examples of defenses they could have. Common law, third parties, obviously the burden of proof is on third parties, and they could, again, sue the auditor for ordinary negligence, but it depends. The auditor can say you have a lack of standing as a third party. Again, causation, and then again, obviously the auditor is going to try to assert, or would assert, that their performance was appropriate, that they performed the audit in accordance with GAAP. I'm sorry, generally accepted auditing standards. And then the final two are security laws, right, under 1933 and 1934. Under 1933, the burden of proof is on the auditors, and usually the ordinary negligence, gross negligence, or fraud. And then in this case, the auditor would be put in a position where they want to show that they conducted the audit with due diligence or that there's no causation. And then the Securities Act of 1934, the burden of proof is on investors to prove that the auditor either acted with gross negligence or committed fraud, and then the auditor again would try to assert that one, they had no knowledge material of the statement, and then that they performed the audit with good faith. In other words, they could perform the audits in accordance with GAS. So those are just, again, some of the sources of liability for the auditor and who has the burden of proof. With respect to Sarbanes-Oxley, obviously it's not that there were, auditors always face legal liability, and what Sarbanes-Oxley did, right, because again, remember a lot of what Sarbanes-Oxley regulated really was to try to improve audit quality, improve transparency, try to mitigate this relationship that auditors have with their clients that could possibly cause them to impair their independence. So one of the things that they did from a legal standpoint is they extended the statute of limitations for bringing a suit under the Securities Exchange Act. And again, so if you think about that, what is sending to the audit profession as a signal is that, there's a long period of time or a longer period of time that you're subject to being sued, right? So they're, again, like it's using regulation or using the fear or the threat of a law, legal action as a way to try to get auditors to stay in line. They increased the penalties for mail fraud and wire fraud, increased penalties for destruction of records, so we all know what that's coming out of because Arthur Andersen destroyed records. So the penalties are increased, and increased the records retention policy. So, all firms had their own record retention policies, and now Sarbanes-Oxley has increased those record retention policies and requirements, and then obviously creating a higher potential liability in civil cases, that could be brought against the auditor by shareholders. With respect to the profession, one of the things, because it doesn't look good, obviously the big cases are out there, right? Everyone hears about them, and we talked about the media and everything being an instant news loop, and it happens, you hear about it. Something happens, I get updates on my phone from the New York Times about any number of things. So people are constantly plugged into what's happening. And so what the profession is trying to do, obviously, is make auditors aware of the types of situations that could lead to legal problems for them, so even things such as research and auditing. So the Center for Audit Quality was started after all of the audit failures, and the Center for Audit Quality consists of representatives from academic community, regulators, members of the profession. All of the firms are represented. And really, what they're doing, one of the things that they've done is to try to spur research and auditing. And there's always been research and auditing. That's what I do. And so they'll come out with call for proposals, research proposals, where they'll say these are some areas that we're interested in learning more about. So they will ask academics to perform research in these areas, and they'll give them funding in some cases and provide them with research support. And so they want to do more of this. So the PCAOB also does this. The PCAOB had a call for academics to look at topics in so many areas, such as professional skepticism, auditor independence, internal controls over financial reporting, audits of fair value estimates, because again, they want to know, because these are the areas, for example, where they saw as a part of their inspection reports where auditors were somewhat lacking, like they were comfortable or not happy with the findings. And so they wanted to get more research, so to think about, well, how do we develop standards? that might help improve auditors' professional skepticism. You know, what situation causes auditors to exercise more or less professional skepticism? I know a little bit more about that because I was on that team that worked on that research project. So, you know, they highlight those areas that are really important that we need to know more about. The other things is we've seen standard and rule setting. As I said, the PCAOB's been issuing auditing standards, such as the audit risk assessment standards. Establish peer review requirements in addition to the PCAOB coming in to audit firms. They're encouraging firms to go through their own peer review process. One big thing that they're trying to do is get firms to oppose lawsuits, right? Because that sends, what happens is I shouldn't say a lot of times, but sometimes firms will just settle. So basically when they're settling, they're not admitting that they did anything wrong. They're just basically saying, look, you know what, we don't want to spend the time and the resources trying to fight this, so let's just settle. Well, and that sends a message to, plaintiffs, people who, will be willing to, it's like, look, we know that they'll settle, so we're never going to have to get to court and have to prove our point, right? Because the firms will just settle because they don't want to deal with the negative publicity. Right? And so you have more and more like these nuisance suits, and if they're settling, then people are more apt to bring those suits. So the profession is trying to get firms to fight these lawsuits more often than not. And then obviously it's sanctioning members if they violate the professional rules of conduct. So just to summarize, protecting the individual CPAs, we already talked about exercising professional skepticism. We're going to talk more about professional skepticism. As an audit firm, you should deal with clients who have integrity, hire people who are qualified, follow the standards, remember the rules, to be loyal to the rules, exercise independence, understand your client's business and the importance of that we'll talk about when we talk about engagement planning, documenting your work, maintaining confidential relationships. So these are the kinds of things that will, if you adhere to these things, or audit firms adhere to these types of factors, then they reduce the risk of being put in a situation where they're being sued by clients or shareholders. Okay.